Hello everyone. This is Dr. P. Kokila, Assistant Professor, Department of Commerce from St.Josephs College of Arts and Science for Women, Hosur. Today's topic is remedies for breach of contract. The Indian Contract Act lays out all the provision for the performance of contract. It also contains the provisions in case of breach of contract by either party. Let us take a detailed look at the available remedies for breach of contract. When a promise or agreement is broken by any one of the parties, we call it a breach of contract. So, when either of the parties does not keep their end of the agreement or does not fulfill their obligation as per the terms of the contract, it is a breach of contract. There are few remedies for breach of contract available to the wronged party. Let us take a look. Cancel contract and relieved of obligation using rescission. Cover and receive damages, different amount, incidental expenses and consequential losses. Demand for specific performance in certain cases and demand injunction to enforce negative clause. Restitution by recovering any consideration already paid and quantum merit for recovering proportionate payment of work performed. Purpose of remedy is to put the harmed party in a good economic position equivalent to that if the contract had been performed fulfilling their expectation. What is suit for damages? When two parties enter into a signed agreement, they commit to fulfilling certain obligations. If either party fails to uphold their promise, resulting in losses for the other party, the latter is fully entitled to initiate legal proceedings and file a damage case. Monetary compensation in respect of loss suffered as a result of breach of contract to put injured party in the same position as if the contract had been performed. Compensatory damages. In tort law, compensatory damages, also known as actual damages, are damages awarded by the court equivalent to the loss a party suffered. If a party's right was technically violated but they suffered no harm or losses, a court may instead grant nominal damages. Compensatory damages paid as a compensation for breach of contract. General damages arise naturally from the breach and are restricted to direct and approximate consequence only. For example, A hires B's vehicle to go to Mumbai to sell some goods and promise to pay after earnings from the sale. But B's vehicle doesn't work and A uses another mode for it. A is entitled for compensation for the inconvenience and other expenses. In compensatory damages, special damages means consequential damages caused by breach due to special circumstances foreseeable at the time of making the contract. For example, A contracts with B to buy 1000 tons of iron for rupees 80 per ton and informs that it is needed in a week to deliver to C to get profit. B fails to give the iron and A claims loss of profits of rupees 20,000 since he would have sold it to C at rupees 100 per ton. If a special circumstances were already in the knowledge of the breaching party, communicating formality may not be needed. Section 73 of Indian Contract Act 1872 says that when a contract has been broken, the party who suffers by the breach is entitled to receive from the party who has broken the contract compensation for any loss or damage caused to him thereby, which naturally arose in the usual course of things from such breach, or which the parties knew when they made the contract to be likely to result from the breach of it. Such compensation is not to be given for any remote and indirect loss or damages sustained by reason of the breach. How to measure the compensatory damages? Measuring of compensatory damages. difference between the contract price and the market price on the date of breach. For example, A promises to B to sell a laptop at rupees 50,000 and fails to do so. The market price of the laptop is rupees 60,000 generally, and B is entitled to claim the difference of rupees 10,000 and buy from someone else, which would cost him only rupees 50,000 now after the claim. Due to mitigate damages suffered. The harmed party may not sit idly and watch the damages accumulate. He is expected to act prudentially to minimize the damages. For example, X took a shop from Y on rent with advance of 1 month rent by Y, who didn't give possession of the shop to X. There were other shops on rent nearby, but X chose not to do business for 6 months and then sued Y, claiming damages including advance and loss of profits for the 6 months. But the court entitled X to only the advance rent as he failed to minimize his loss. What is nominal damages? Breach of contract is proved but failed to prove any actual damage has been suffered. Not always easy to measure damages, and law requires damages to be foreseeable and proved with certainty. Nominal damages given to recognize the right of injured party to claim damages. For example, a contracts to purchase a bike from B but fails to do. The market demand exceeds the supply and B is able to sell it to C for the same amount. Then B is entitled to receive only nominal damages if he claims. Thank you.